Good morning to everyone. Let me announce you that today we have interpretation for French, German, Italian, English, Spanish, Polish, Bulgarian, and Croatian. The speakers are invited to speak on their mother tongue if interpretation is available. For those who are following today's committee virtually, just to remind them that whenever they want to take the floor, they have to press the raise the hand button, and then when the floor will be given to them, they will have to press the speak button. This meeting is web streamed, and if there are no objections, I consider the draft agenda adopted as modified. Let me, before moving to item 4, item 3, subsidiarity rule 43, just an announcement. The following recent opinion has been received from national parliaments. Proposal for a regulation of the European Parliament and of the Council establishing the framework for achieving climate neutrality and amending regulation 2018-1999 European Climate Law from the Netherlands Senate. And now we move on to item 4, exchange of views in the context of a structured dialogue with Margrethe Vestager, Executive Vice President of the European Commission for a Europe fit for digital age. Executive Vice President, it's an honor and a pleasure to have you here today with us. I was really happy to know that you were coming to our committee, and I hope that soon enough we will have you again here, but physically and not only virtually. Let me recall to the colleagues today that this exchange of view will take place within the structured dialogue between the Parliament and the Commission pursuant to Annex 4 to the Framework Agreement on relations between both institutions on the timetable for the Commission's work programme, and it will provide a dialogue within the implementation of the Commission work programme for 2020 and on the preparation of the Commission work programme for next year's. Let me recall that on May 27, 2020, the Commission made public a review work programme for 2020 with implications also for the work of this committee. So now, Executive Vice President, I'll give you the floor, and you'll have 10 minutes, and then we'll move on to the coordinators of the different political groups. The floor is yours, Ms. Vestager.
Mrs. Vestager, may I kindly ask you to press the speak button, please?
I'm sorry.
Thank you.
I'm sorry. It just that the microphone was open, so I didn't realize. Well, anyway, I am still honored and thankful to be with you, Honourable Chair and Honourable members. I will be looking forward to be with you in person, but I'm very happy for the invitation to this structured dialogue. And the reason why we can be here in this format is, of course, that we have been in a completely unprecedented situation. The COVID-19 crisis has affected everyone, of course, in different degrees, someone ultimately, but every region, every country, every person. What started with isolated cases very, very quickly turned into not only a global pandemic, but also a global economic crisis. It has unprecedented proportions, and it is indeed a tragic situation. The Commission's unwavering focus has been to protect lives and livelihoods. Since the beginning of the crisis, the Commission has adopted more than 400 decisions and acts as a direct response to the health crisis. All of these were neither planned nor were they featured in the Commission work programme for this year. As part of the recovery package, we of course have adjusted the work programme for this year, and that adjustment has been based on two principles. First, the Commission is determined to deliver on the commitments made on the 2020 Commission work programme. And second, because of the nature and the scope of the health crisis, the timing of some of the proposals have had to be reviewed. President von der Leyen, she said on the occasion of the recovery package, the European Green Deal and digitization will boost jobs and growth, the resilience of our societies, and the health of our environment. So, of course, the European Green Deal and the digitization is at the heart of the recovery plan and the next multi-annual financial framework. And this also means that the initiatives which are essential to support the immediate recovery, they will be adopted as initially planned. With this, we focus in particular on initiatives that allow us to press fast forward on the green and digital transitions. And these include for digital, first, the Digital Services Act and the new competition tool, the review of the Directive on Security of Networks and Information Systems, the NIS directive, together with a cybersecurity strategy. Third, the recent white paper on an instrument on foreign subsidies. Fourth, the communication on the future of research and innovation and the European research area. And fifth, communication on Horizon Europe research and innovation missions. Three elements will be the key for a digital recovery that will help stimulate competitive innovation, but also provide users with greater choice. First, we need to invest in more and better connectivity. I think everyone has seen in this sort of crash course of doing everything digital that connectivity is of the essence. Second, that we build a real digital and data economy as a motor for innovation and job creation. I think this is also a precondition for the promotion of trustworthy AI in Europe, that we have this data economy. Third, that we promote also a digital single market, and we promote the ease and the fairness of doing business in Europe. And these three elements, they must be addressed in order to make most of our digital recovery. In this spirit, one of the aims of the Digital Services Act will be to improve the legal framework for digital services with clear rules for online platforms. In this context, we're also exploring a new competition tool that would allow addressing structural competition problems in a timely and effective manner in order to prevent new gatekeepers from arising. Digitization of public procurement, including by developing national e-procurement systems and platforms, will be a priority. And this will be supported by a full implementation of a company law package to facilitate digitization and the mobilities of companies and a single digital gateway. There is a slight delay for a number of initiatives, but that reflects the need to learn and integrate lessons from the crisis to allow for time for proper consultation, to better incorporate the results of delayed discussions at European or international level, or to ensure that principles of better regulation, that they are fully respected. Where possible, we will expand the opportunities for public feedback on our initiatives to accommodate for the difficulties that citizens and stakeholders and businesses may have had in order to provide for their input in these times of crisis. The recovery will need a strong policy direction as well as investments, which is one of the reasons why I'm very, very happy with the Next Generation EU, the recovery plan and the multi-annual financial framework. It was a very strong moment in the Parliament when Next Generation Europe was presented, because this very strong support of the Parliament, the trust and the very close cooperation that we can make this happen. We can make Europe recover fast and strong to the benefit of every citizen. I think it means a lot to feel that strong support and that strong willingness to make sure that work is being done in a timely fashion in order for Europeans to see that they can really count on their European democracy. Thank you very much. I'm looking very much forward to our exchange.
Thank you very much, Vice President, for this very comprehensive and clear statement. We'll move on now with the coordinators of the different political groups. The structured dialogue of today the question time will be structured as follows: 2 minutes for each coordinators. Then we'll give the floor back to the Vice President, and then we'll finish today hearing with Ms. Vestager with 1 minute per speaker. The first speaker is Ms. Wolfman from the EPP group, and you have 2 minutes. The floor is yours.
Ja, guten Morgen. Vielen Dank, Herr Vorsitzender. Sehr geehrte Frau Kommissarin, 2 Themenbereiche, zu denen ich Sie gerne etwas fragen würde. Der erste Themenbereich betrifft die künstliche Intelligenz, einer meiner Schwerpunktbereiche. Vor allem auch in der Covid-19-Pandemie haben wir bemerkt, wie hilfreich die KI-Anwendungen sein können, um so eine große Krise meistern zu können. Die Corona-App ist dabei nur eines von zahlreichen Beispielen. Federführend sind Sie zuständig für die Erarbeitung eines Rechtsrahmens für KI. Wie wollen Sie bei dem Rechtsrahmen den Ausgleich schaffen zwischen der Schaffung von Rechtsklarheit, um das Vertrauen der Verbraucher in die neuen Technologien zu stärken, und der Vermeidung von Überregulierung? Zu viel Verwaltungsaufwand bzw. bürokratische Hürden hindern die Innovationsbereitschaft der Unternehmen und ersticken die Möglichkeiten insbesondere von KMUs und Start-ups im Keim. Und schließlich wollen wir es den europäischen Unternehmen erlauben, sich europäisch international zu behaupten. Deshalb auch die zweite Frage: Was ist, wenn 2 größere europäische Unternehmen sich zu einer KI-Kooperation zusammenschließen wollen würden? Wie sollen wir zu EU-Champions werden, wenn die Wettbewerbsregelungen es erschweren, ein starkes europäisches Unternehmen zu schaffen, welches auf internationaler Ebene bestehen kann? Und der zweite Themenbereich ist das geistige Eigentum. Der Diebstahl geistigen Eigentums durch Drittstaaten schadet unserer Industrie in großem Umfang. Und es gibt berechtigte Bedenken, dass bestimmte Unternehmen europäischer Firmen ausschließlich dem Wissenstransfer dienen. Diese Praxis nimmt der europäischen Innovation auf dem globalen Markt den Wettbewerbsvorteil. Hat die Kommission dies als ein Problem für die globale Wettbewerbsfähigkeit der EU erkannt? Arbeitet die Kommission an Lösungen für dieses wichtige Problem? Das wären meine Themenbereiche. Dankeschön.
Thank you very much, Ms. Wolfman. Now the floor is for Mr. Wolken. Mr. Wolken, you have the floor.
Yes, good morning. Thank you very much. Dear Executive Vice President Vestager, thanks for being here with us again. As you know, this committee is actively engaged in the drafting of the report on the Digital Services Act, for which I am the rapporteur. Last week, we all learned that the French Constitutional Council declared large parts of the anti-hate speech law in France, which is of importance in the context of the preparations for the DSA, to be inadmissible. The Council has based its ruling not only on the French Constitution, but also on French law implementing the e-commerce directive and, most importantly, the Declaration of Human Rights and on the citizens of 1789. I appreciate that the ruling is based on considerations on the practical implications of the proposed law for the exercise of fundamental rights online, and thus sends a very important signal for our work on the DSA. In my assessment, the lessons to draw from this ruling are the following. Overblocking of lawful content is no longer a mere side effect of platform regulation that we must accept, but a substantial reason for regulations to be inadmissible if they lead to overblocking in practice. Second, tightening liability provisions will not lead to more effective platform regulation, as this incentivizes overblocking by platforms who act in order to remain exempt from liability. Madam Vice President, this ruling brings to the foreground an argument that many digital fundamental rights activists have been repeating for years. We must take fundamental rights infringements online seriously. My question to you is therefore, what lessons does the Commission draw from the ruling on the law? How will the Commission frame its proposal for the Digital Services Act in order to preventing the effect of overblocking and fundamental rights infringements in content management? Thank you very much.
Thank you. Ms. Melchior.
Thank you very much, and thank you, Ms. Vice President, for being here. Thank you, Margrethe. You mentioned the need for having an improved legal framework for platforms when mentioning the Digital Services Act. There is a worry that we will be making regulation that apply to all platforms indiscriminately, and that it will be easier for the larger platforms to be able to comply with the regulation. One of the approaches to this would be to make a differentiation between the different platforms. The Commission is looking at having an ex-ante control of platforms seen from a competition point of view to the platforms, as you mentioned, that are seen as gatekeepers. But I think it's also necessary to look at implementing this into the way that we regulate platforms so that the criteria, the regulation that we apply to platforms in general are not, we don't apply too stringent demands on the smaller platforms. In the own initiative report from this committee, we from the New Europe Group have suggested having a definition on so-called dominant platforms or systemic platforms. How does the Commission see that these should be defined? And also in the introductory remarks, you mentioned that we need to have a better choice for users of platforms. How do we make sure that there is a real choice for users of these dominant or systemic platforms? How do we open up the platforms so that the users have a real choice between, for example, content curation options provided by platforms or perhaps by others? So how do we ensure interoperability, interconnectivity between platforms? And how do we define which platforms need to meet higher demands than others because they have a specific role, not only in the market, but also in our society as the online platform for our democratic debate? Thank you.
Thank you very much. Mr. Le Breton, the floor is yours.
Merci, Monsieur le Président. Madame la Commissaire, vos services réfléchissent plus que jamais sur l'avenir du droit de la concurrence, à travers notamment un livre blanc. Vous avez déclaré que la crise sanitaire et économique était une occasion pour l'Union européenne de se renouveler en la matière, et vous parlez de fin de la naïveté, notamment vis-à-vis de la Chine. Alors vous annoncez un contrôle des aides chinoises pour éviter les distorsions de concurrence. Vous reconnaissez que par le passé, on n'a pas procédé assez ainsi. Vous notamment citez l'exemple des marchés publics. Dans l'ouverture au marché public, il n'y a jamais eu de réciprocité. Et pour l'avenir immédiat, vous dites qu'il faut faire attention au rachat d'entreprises européennes en difficulté par des entreprises qui seraient subventionnées par la Chine. Alors, d'où ma première question. Quelle solution préconisez-vous lorsque vous découvrirez que de telles entreprises subventionnées par la Chine envisagent de racheter des entreprises européennes en difficulté? Est-ce que vous êtes prête à aller jusqu'à l'interdiction d'achat ou est-ce que vous vous contenterez d'un système d'indemnisation comme vous l'avez déjà évoqué? Deuxième question, on parle beaucoup des réseaux 5G qui constitue l'avenir du numérique, et on sait qu'en la matière, des entreprises chinoises se sont positionnées. Donc, quelle va être votre attitude à l'égard de ces entreprises chinoises? Que prévoyez-vous pour assurer la sécurité des réseaux 5G? Troisième question, sur les GAFA. Vous avez ouvert 2 enquêtes pour pratiques abusives à l'encontre d'Apple. Donc je crains que ça contribue à vous discréditer davantage aux yeux du président Trump, qui vous appelle la tax lady. Mais enfin bon, ça n'est pas très grave à mes yeux. Mais pour devenir plus sérieux, est-ce que vous ne pensez pas que cela est révélateur du fait que ces GAFA américaines sont de plus en plus puissantes et qu'elles ont été renforcées par la crise? Pensez-vous qu'elles ont été renforcées par la crise? Vous avez parlé de bataille de souveraineté en soulignant que ces GAFA tentent d'imposer maintenant leurs propres mesures. Vous aviez évoqué ça à propos de Google, qui essayait d'échapper à la directive sur les droits d'auteur. Et d'où ma dernière question. Êtes-vous favorable à la création d'un champion européen du numérique pour essayer de brider le pouvoir de ces GAFA américaines? Merci.
Thank you very much. I had on the list Mr. Dambaski from the ECR group, but he's not connected. But maybe Mr. Stancanelli, would you like to take the floor on his behalf? If so, go straight and press the speak button.
Mr. Stancanelli, could you please press the speak button, please?
Fatto. Sente?
Yes, please speak.
Please speak. Bene, grazie Presidente. Ringrazio la Vicepresidente per la sua presenza stamattina in Commissione e per la relazione che ha fatto e preliminarmente vorrei esprimere la soddisfazione del mio gruppo per l'iniziativa del libro bianco che la Commissione vuole predisporre, un libro bianco dedicato appunto alle distorsioni che possono essere nel mercato unico per le sovvenzioni estere, e già si è fatto riferimento anche agli interventi degli Stati Uniti o della Cina, e mi auguro che vi sia una ampia consultazione al riguardo per far sì che non si verifichino appunto queste distorsioni. Ma l'aspetto che io voglio sottolineare, per cui poi mi rivolgo alla Vicepresidente, è la questione relativa, affrontata anche da altri commissari stamattina, relativa ai cosiddetti GAFA e tutte le altre piattaforme del nostro mercato. Vorrei capire come si possa lavorare per una vigilanza costante sul loro operato, perché siano rispettate le regole della concorrenza e perché i consumatori possono essere garantiti e usufruiscono dei loro servizi nella più assoluta correttezza, rispettando anche coloro i quali le piattaforme più piccole e che ovviamente con una loro regolamentazione possono sicuramente offrire servizi migliori e più competitivi agli utenti. Ecco, questa è la domanda che io faccio. Per il resto sono a disposizione con il mio gruppo per collaborare in un momento di grave crisi per tutti i paesi europei dopo la crisi sanitaria. Grazie Presidente.
Thank you very much. Mr. Lagodinsky, the floor is yours.
Thank you so much, Ms. Vice President. It's great to see you here. 3 points. One point, as already been mentioned, probably IBM, Microsoft, and Amazon have committed themselves in the light of the racism debate in the United States not to sell facial recognition and various shadings to law enforcement authorities. And the question that I have is, what is the position of the EU Commission? Are we going to follow the same path, both for law enforcement, but also I think where there is a lot of discrimination potential is also for public spaces and using this technology there in our streets and parks. The second question is, you mentioned the 3 elements for recovery, you mentioned some elements of the plan. What are the specific artificial intelligence files and projects that you're going to be pushing for? We have plenty of reports, but it's not clear to me and to many of us what is the legislative agenda of this commission in that aspect. And my final question is, you talked about public administration on EU level, digitalization. What are the plans in that respect that you're planning to digitalize public administration beyond the couple of the public procurement example that you mentioned, because this is obviously a very important component of upcoming digitalization agenda. Thank you very much.
Thank you very much. Ms. Aubry, the floor is yours.
Ms. Aubry, please press the speak button.
Bonjour à tous, j'espère que vous m'entendez. Bonjour Madame Vestager et merci d'être avec nous aujourd'hui. Je veux aussi vous interroger sur les aides d'État qui ont été versées. C'est beaucoup d'argent depuis le début de la crise et c'était nécessaire, plus de 2 000 milliards d'euros qui ont été autorisés par la Commission européenne, même si on peut regretter une certaine inégalité entre les différents États membres. En France, par exemple, on a eu 23 milliards d'argent qui ont été injectés pour les secteurs aéronautiques et automobiles, avec 5 milliards d'euros pour Renault, qui va supprimer 4 500 emplois en France, et sans engagement sur la limitation du secteur, notamment des SUV qui sont les plus polluants. On a eu 7 milliards d'euros pour Air France, qui va supprimer au moins 8 000 emplois, et sans engagement sérieux non plus sur l'environnement. Et pour nous, l'enjeu, c'est de ne pas répéter l'erreur de 2008 avec un sauvetage inconditionnel des banques sans mettre en place de garanties sérieuses de régulation bancaire ni contrepartie. Et là se pose de nouveau la question d'un plan de relance ambitieux, mais qui propose des contreparties avec une vraie puissance publique stratège qui donne le cap, la vision de long terme et qui accepte d'être en quelque sorte tutrice de l'économie, mais pour des bonnes raisons. Et c'est pour ça que nous défendons évidemment des aides d'État, mais qui soient assorties de contreparties pour s'assurer que les entreprises qui bénéficient d'aides d'État ne licencient pas massivement, n'investissent pas dans les paradis fiscaux, ne versent pas des dividendes extrêmement généreux à leurs actionnaires, ni ne continuent à développer de modèles polluants et au contraire qu'on les aide à faire la nécessaire bifurcation écologique pour transformer notre modèle économique à l'aune des enjeux d'aujourd'hui, puisque le prochain défi et le défi actuel, en plus de cette crise sanitaire, c'est bien sûr la crise écologique. Donc ma question est assez simple finalement, puisque vous évaluez actuellement votre politique de la concurrence et vos aides d'État, envisagez-vous de demander des contreparties aux entreprises qui sont bénéficiaires d'aides d'État pour redonner à la puissance publique son rôle de stratège dans la défense de l'intérêt général, social et économique. Merci beaucoup.
Thank you very much. Mr. Kolakusic.
Hvala. Poštovani predsjedniče, poštovane kolege. Digitalizacija je, kao što svi znamo, budućnost i preduvjet za veliku i snažnu Europu. Ono o čemu najviše moramo voditi računa je da okrenemo smjer kojim idemo. Sada Europa nije predvodnik u digitalizaciji. Predvodnici su Kinezi, Amerikanci. Mi govorimo o budućnosti 5G mreža koje će donijeti Europi blagostanje. Neće. Jer ono čime vi ne upravljate, ono što je strana tehnologija, to donosi onome ko ima tu tehnologiju. Mi se moramo snažno okrenuti zajedničkom razvoju svih platformi, od socijalnih mreža, od web trgovina, od izrade tehnologije gdje smo nekada bili najjači. Pa sjetimo se Philipsa. Pa Philips je izmišljao sve strojeve koji su nam bili važni i potrebni. Moramo biti Europa, moramo sve snage zajedno i moramo se dakle iznići iz ove situacije da smo samo korisnici stranih tehnologija i rješenja. Hvala.
Thank you very much. Madame Vestager, the floor is yours.
Well, thank you very much. And also thanks for the detail and breadth of questions. I think it shows very clearly the nuance and the difficulty with what we're facing, but also the sense of urgency that I share. On Mrs. Walsman's question on AI, the COVID-19 crisis has been shown that it is. I have an echo. Do you have an echo as well?
No, right. We don't have it actually. We can hear you quite clear.
If you're fine, I will try to divert my attention from it. No, the thing was that during the crisis, it really showed that AI is very useful. It has been used in numerous occasions in order to help out research, in order to process tests faster. We have made good use of high-performance computing here in order to establish models that could help decisions makers in what to do as how to deal with the virus. Now we have the public consultation of the AI white paper ongoing because it is exactly as Mrs. Walsman says, legal clarity versus over-regulation. Of course, no one wants to over-regulate, but that is how it can feel sometimes. The most interesting or vivid debate is the core, this risk-based approach, how to define what is risk, because technology that is not risky in some circumstance can indeed be risky in other circumstances when it comes to fundamental values, like being free of discrimination. Of course, we will take the input from the public consultation. I think we have had around 1,200 contributions. My starting point will be how to make sure that we can create the necessary trust for people to engage with the development of artificial intelligence. I think that is the fundamentals, and that trust can only be built if those who built and use and develop artificial intelligence, they have a clear legal framework as to what is acceptable and what is not. When it comes to mergers also of companies which are doing artificial intelligence, of course, as in any other business, they can merge as long as they are still being challenged in the market that they address, because that is the fundamental. Mergers are one of the many ways to grow a company, but the thing is that for every company, you have to accept that you are being challenged and you are being held up to the standards of fair competition. On the question of IP use in third countries, I don't have a very clear answer to that, and I'll be more than happy to come back to it. Mr. Volken, who is the rapporteur on the Digital Services Act, I will be looking very much forward to see your thoughts and the debates within the Parliament. The question of the French legislation, I think that's also an input that is needed for our consideration, how to balance that some things should be blocked if clearly illegal, while at the same time to make sure that in the grey zone between what should definitely not be blocked and what should definitely be blocked, that there are the right ways of redress, so that if there is doubt, that things can be discussed And if some things are being blocked that should not be blocked, that it can be indeed unblocked again in a way that is accessible also for people who do not have technical skills or who would never ever consider hiring a lawyer to help them have their fundamental rights, because having your fundamental rights and being able to enforce it, of course, is the task for the legislator and for us as Commission. Mrs. Melcher is asking about the difference between small and big platforms. And here, one of the things that we are consulting on now is indeed what should be sort of the special responsibility of platforms that gets to play a role as gatekeepers. Of course, it is a tricky thing to define what is a gatekeeper, because it has to do with a territory that is framed with the concepts that we do know about essential infrastructure, being dominant sort of in the understanding of competition law, and having market power sort of in a broader concept of that. And that, of course, is important. But the second thing that is important is also ex ante, to be able to address market structures that leads to a risk of a market tipping, so that new gatekeepers are being created, because that would limit the possibilities of smaller companies, smaller platforms actually to make it. But I think there is a thing here that ought to be for everyone, and that is to discuss something fundamental is, of course, at stake. We live in societies who cherish fundamental values, and we do our best to put it into real life. So there must be fundamentals that also small platforms should be able to live up to, while, of course, there should be a special responsibility for those who have developed into gatekeepers. On the question of how to avoid European companies to be bought by Chinese, as said actually now a couple of months ago, I think it's very important to be vigilant that companies who might be weakened by the economic crisis following the COVID-19 crisis, that they are not just left in the cold to whomever who might want to buy it. It may even be so that a state may be willing or have to be willing to take a stake in a company in order to prevent a hostile takeover. For the future, we are planning, and that was the purpose of the white paper on foreign subsidies, to have the necessary tools in the last event, also to ban a merger if we find that merger is being fueled by foreign subsidies. And the logic here is very simple. In Europe, we control state aid. In Europe, we have transparency on state aid, and we hold our companies to a standard of fair competition, which also means that if European companies or companies doing business here in Europe are being challenged by companies who are fueled by subsidies from foreign countries where we have no control or no transparency, then of course we need a tool that we can use here, both a specific tool in the situation of a merger, but also a more horizontal market tool that would allow us, if we hear it, if we see it in the media, if someone complains, that we can go in and investigate whether indeed foreign subsidies are unleveling the playing field. What Mr. Stancanelli is saying, I'm very happy, of course, that you appreciate the white paper. It is indeed a broad consultation, and we hope, of course, for as much input as possible. Also on the issue as to how to make sure that it's an effective instrument, because that is, of course, where you find the real test. It is if this instrument is actually useful. So also on the procedures, how to make sure that our investigations can be useful, because we are in unprecedented territory. This is new. It has not been done before. It doesn't exist anywhere. And we are trying to investigate things where we are sort of well, of course, in our own jurisdiction, because these are businesses doing business here, but we cannot ask the same questions as we would to someone who were truly established. So it is indeed important with a broad, consultation. On the question of how to ensure that we constantly are vigilant with the gatekeepers, with the GAFAs. Of course, I have an obligation to make sure that my services and the Commission as such stays vigilant on competition enforcement. And you've probably seen that we have opened 2 cases concerning Apple, both concerning Apple Pay and concerning the Apple Store, the Apple App Store, for the commercial practices here when Apple are in competition with other companies, that being music or news or other issues. On the question of Mr. Lagundinsky on the no sale of facial recognition by a number of big companies, I think this is indeed crucial because there is a big difference between using facial recognition directly in a gadget or as a biometric identification in your passport, and then have facial recognition sort of large scale in public space. Of course, one can make very specific legal provisions for the use of facial recognition, but what we have suggested in the white paper is indeed an in-depth debate about whether or not we would want to have that kind of surveillance in public space, because, as you say, it changes our society if we are constantly over surveillance. And it's not just facial recognition, it's also technology that can recognize how you walk, how you gesture, how you behave in public space. And I think it is very important that we keep the public space for the public and not for authorities and this surveillance that we are discussing here. On the question of digital public administration, e-procurement should not be seen as a minor thing. It's a giant thing. It can produce better market opportunities for smaller businesses. It can make it easier to participate in public procurement. It can create transparency as to what procurement processes are open. So it will be a giant step forward if that can happen. It will be interesting to see how governments have pushed digital services during the COVID crisis, where people couldn't come in person for the different services. And of course, things are being considered. You will see that in our DESI index as well. Mrs. Aubry-Manon is asking about state aid, and it's indeed also how I see it. Huge amounts has been approved by us. I think by now 2.3 trillion euros. We have been working very hard to approve all this aid. And the reason why we make such an effort is, of course, to make sure that even though the flexibility is unprecedented, so much more aid is enabled because it's needed, we are very careful in the checking, sort of to minimize disturbance of competition and the fragmentation of the single market. It is also, the numbers also show that there are huge differences between the amount of state aid being handed out. I think the silver lining to that is that if a business in one country is being aided, then of course that business may remain a good customer of a business in another country, or a good supplier of a business in another country. But that being said, one of the reasons why I find that Next Generation Europe, the recovery plan, is so important is indeed that will give a context and a framework for what individual member states are doing for the economic recovery, to make sure that this is a European recovery and that it is fast and strong. One of the things in that respect would be the solvency support instruments that would enable to crowd in private funding for businesses who need to renew their capital base. When it comes to state aids, these days we're working on a legal basis that allows exactly for help in these crisis situations, which is why we cannot we cannot put strings on it, but we are encouraging member states to do what they find proper. For instance, France have made a deal with Air France on greening that business. When it comes to the European Recovery Plan, of course, we have different options. Again, let me promote the solvency support instruments, because here that should indeed adhere to the do no harm principle, but also that there are green and digital plans for the businesses who would benefit from this. On the last question of Europe not leading, I think it's very important to see what we missed out. And one of the things we missed out was indeed a digital single market, where both Chinese and US now giants could grow in a single market, both in China and in the US. We still allowed the European market to be fragmented. And we shouldn't allow that because we have assets and competences that could allow European businesses to develop also strong positions, for instance, in the business-to-business digital sphere. And that is very important, but that can only happen if we provide them with a market that demands their services and that has the size in order for them to develop scale. So things, of course, come together. And we will, of course, use a number of foreign-based services because they're high quality, because they're good, because it serves as well to be an open economy. But when you do business in Europe, you will always be held accountable, no matter where you come from, that your services are not being done in a way that hampers fundamental values. This is the purpose of the changes of the Digital Services Act, the e-commerce directive, but also that you're held to a standard of fair competition, which is why we had very active competition law enforcement with the Google cases, the Amazon case, the now opened new Amazon case, and the two brand new Apple cases. Thank you.
Thank you very much. We move on now to the second round of speakers. Just to remind you that you will have 1 minute each. The EPP speaker in my list is not connected. I don't know if Mr. Zarzalejos or someone else from the EPP group would like to take the floor.
Sí, muchas gracias, presidente. Yo quisiera en este segundo turno de preguntas profundizar en una idea que ya ha salido en relación con la vuelta a un régimen de cierta normalidad en el ámbito de la competencia en la Unión Europea. Sabemos que, en cierto modo, el régimen de competencia dentro de la Unión Europea prácticamente ha saltado por los aires en esta situación de emergencia, pero también sabemos las extraordinarias e intensas consecuencias que está teniendo sobre la integridad del mercado interior. Me gustaría si la comisaria pudiera elaborar algo más sobre la perspectiva de recuperación de la integridad del mercado interior después de este periodo de turbulencia.
Muchas gracias, señor García Blanco.
Sí, muchas gracias, presidente. Es un placer volver a estar aquí. Gracias, señora vicepresidenta. Quería preguntarle alrededor de algunas de las cuestiones que se han suscitado durante las preguntas anteriores, pero en más profundidad algunas cuestiones, porque es verdad que al comienzo del mandato la Comisión, en este caso la presidenta de la Comisión, planteó que uno de los grandes retos de la Comisión sería establecer una reglamentación alrededor de un control ético alrededor de la inteligencia artificial. Este Parlamento lo está haciendo. Ya yo mismo como ponente he presentado una norma en ese sentido y la estamos trabajando en este momento en el periodo de enmiendas. Me gustaría preguntarle más concretamente sobre si se puede comprometer a respetar de alguna forma aquello que evacúe esta comisión y el Parlamento como conclusión, porque sería importante de cara a establecer una norma efectiva. Y en segundo lugar, alrededor de algunas de las aplicaciones muy concretas, y termino muy rápidamente, me gustaría saber cuál es su visión acerca de las herramientas de reconocimiento biométrico, por ejemplo, o las tracing apps, que en este momento están tan de moda en el debate, pero que necesitan regulación no solo para situaciones de emergencia, sino también las necesitaremos en un futuro. Gracias.
Gracias. Ms. Melchior.
Ms. Melchior, please press the speak button.
Perfect. Following up on my colleague's question, I would also like to address the question of the tracing apps. Thank you very much for the Commission's guidelines, which emphasize the need for interoperability of the tracing applications. However, we see that member states such as Germany and Denmark have launched tracing applications tracing the COVID-19 virus that are not interoperable with other member states' applications. How do the Commission plan on addressing this issue and make sure that the guidelines that the Commission come with are actually being followed by the member states when they implement their applications? Thank you.
Thank you very much, Mr. Le Breton.
Merci, Monsieur le Président. Madame la Commissaire, je n'ai pas eu de réponse claire sur le point de savoir si vous souhaitez la création d'un champion européen du numérique. Donc je reviens à la charge. Pour le reste, j'aimerais revenir à l'actualité la plus immédiate. Vous avez reproché au gouvernement français d'avoir mis en place le système Stop Covid parce qu'il est très difficile à connecter aux autres systèmes européens équivalents. Mais il y a plus grave, un chercheur vient de démontrer que ce système ne respecte pas les règles de protection des données personnelles. Stop Covid collecte en effet les identifiants de toutes les personnes croisées par chaque utilisateur et pas seulement, comme c'était annoncé, celles des personnes croisées à moins d'1 mètre pendant 15 minutes. Donc j'aimerais savoir comment vous jugez ce type de dysfonctionnement. Et comme il me reste 8 secondes, j'aimerais ajouter que, contrairement à ce qui a été dit, le Conseil constitutionnel français a totalement anéanti la loi Avia pour violation de la liberté d'expression.
Thank you very much. Mr. Lagodinsky, would you like to take the floor?
Mr. Lagodinsky, please press the speak button.
Yes, thank you once again. A follow-up on the digitalization of administration. We have, I understand that procurement is, of course, an important point, but still, going beyond that, we as a parliament have a call for open and transparent administration. Heidi Hautala was very active on that from this committee. It would be interesting to know how we can develop this. And the other question on apps, as mentioned by our colleagues, we have this situation in Germany. How do you want to secure the effective voluntarity of these apps, especially regarding situations where, for example, stores or during public events, people will only be allowed if they have an app? In Germany, we're talking about that we need a law that would actually regulate contracts and private contracts that will ban such preconditions. What is the position of the Commission? Because otherwise it's not really voluntary. Thank you very much.
Thank you very much, Mr. Lagodinsky. Mr. Stancanelli, would you like to take the floor?
Mr. Stancanelli, please press the speak button.
Pronto?
Yes.
Pronto?
Go on, Mr. Stancanelli.
Sì.
Go on, Mr. Stancanelli.
Grazie Presidente. Io ho apprezzato le risposte che la Vicepresidente ha dato in relazione alle mie due osservazioni e alla mia domanda, cioè relativamente al libro bianco, dove auspico che ci sia appunto una grande partecipazione e consultazione di tutti gli interessi in campo, e la Vicepresidente ha dato come posso dire, ha dato un'affermazione positiva a questa mia osservazione, e il secondo invece è la problematica sui GAFA, che è una problematica seria sulla quale dobbiamo lavorare, perché dobbiamo impedire che il nostro mercato venga sopraffatto da interventi non europei, e anche in questo senso ho accolto con soddisfazione il desiderata della vicepresidente e quindi della Commissione. In questo senso come ECR noi parteciperemo perché queste volontà vengano non soltanto rafforzate ma sostenute. Grazie.
Thank you very much. Mr. Morel, the floor is yours.
Oui, merci Monsieur le Président. Madame la Commissaire a dit qu'il fallait que les entreprises acceptent d'avoir des concurrents. Mais alors s'il y a bien un domaine où il y a de moins en moins de concurrence, c'est en effet celui des GAFAM, parce que le confinement a favorisé le recours aux applications numériques, mais il y a aussi une loi économique, c'est qu'en temps de crise, ça accélère la concentration du capital. Et en termes de concentration, dans ce domaine, on ne fait pas pire. Et ce que je ne comprends pas, c'est que vous êtes très prompte à empêcher des fusions, par exemple Siemens-Alstom ou PSA-Fiat, on pourra en discuter, mais par contre, vous continuez à dire, je vous cite, en octobre dernier, le démantèlement c'est un outil disponible, mais celui des GAFAM n'est pas d'actualité. Moi, je pense que c'est totalement d'actualité. D'ailleurs, même aux États-Unis, dans le cadre de la loi antitrust, ils commencent à y réfléchir. Deuxième question, très rapide, sur les marchés publics et l'acquisition d'entreprises étrangères. Moi, je trouve que le livre blanc, il est intéressant, mais il est vraiment trop timide et trop compliqué sur cette question. Quand on envisage de faire 3 niveaux d'enquête, plus des formulaires innombrables pour les entreprises européennes, ça me paraît vraiment compliqué. Il faut qu'on préserve, il faut qu'on protège nos entreprises, mais il faut absolument simplifier le dispositif que la Commission est en train d'imaginer. Merci.
Thank you very much. Mr. Kolakusic.
Hvala. Mi u današnje vrijeme raspravljamo o aplikacijama za praćenje. Izražavamo naravno ozbiljnu zabrinutost radi toga, jer pravo, dakle, osobnog života i tajnosti osobnog života je jedno od temeljnih prava. Međutim, u današnje vrijeme svako od nas koji ima mobitel pristankom da koristi bilo koju aplikaciju, prvenstveno aplikacije iz Googlea, vi pristajete da budete praćeni 24 sata dnevno. Svaka vaša izgovorena riječ, sve što pretražujete se sprema u baze podataka, navodno da bi se vama omogućilo lakša kupovina, prikazivanje reklama. Pa vidjet ćete, dakle, upišete bilo koji pojam ili s nekim razgovarate, vama će se pojaviti reklama proizvoda o tome. Mi u ovom trenutku smo praćeni 24 sata dnevno. Svaki onaj ko može ući u vaš Google ili neki drugi akaunt od temeljnih platformi moći će vidjeti gdje ste vi bili prije 3, 4, 5 godina točno u milisekundu. Mi moramo tu prvenstveno izgraditi regulaciju da omogućimo građanima da se koriste tim aplikacijama, jer oni su postali sastavni dio naših života, ali da im se omogući bez konstantnog praćenja. Ovako mi postajemo, dakle, mali zamorci o kojima strane kompanije imaju sve podatke. Hvala.
Thank you very much, Mr. Kolakusic. Ms. Gerhardt? I have you on the list. So the floor is yours.
Ja, danke schön, Herr Präsident. Danke schön, Frau Vizepräsidentin. Hier im Europäischen Parlament haben wir zurzeit eine heftige Diskussion darüber, ob das Haftungsrecht sich ausschließlich auf Hochrisikoprodukte beschränken sollte, und zwar Hochrisikoprodukte, was physikalische Schäden angeht. Habe ich Sie richtig verstanden vorhin, dass Sie diese Herangehensweise auch skeptisch sehen, denn Risiken, die gegenüber Menschenrechte, Bürgerrechte, werden dadurch nicht abgedeckt, und das wäre sehr, sehr problematisch. Die zweite Frage, die ich anschließen möchte, auch im Bereich des Haftungsrechts: Wie planen Sie sicherzustellen, dass alle Arten von KI-bezogenen Schäden angemessen und vollkommen entschädigt werden, ohne dass die Beweislast auf Geschädigte oder Nutzer alleine fällt?
Muchas gracias, señora vicepresidenta. Presidenta, antes de darle la palabra para terminar la sesión de hoy y responder la segunda ronda de preguntas, quería incidir en un tema que han sacado la mayoría de los compañeros, que son las aplicaciones de trazabilidad. Más allá de las preocupaciones concretas que los guidelines de la Comisión del pasado abril cubrían, como la necesidad de que sean descentralizadas, que no sean intrusivas, que respeten la privacidad de los usuarios y, sobre todo, que sean interoperables, hemos visto, y yo creo que es el verdadero problema que subyace con un tema como el de las apps, que al no haber una coordinación, al no haber un verdadero interés de los Estados miembros en conseguir una soberanía digital a nivel europeo, las aplicaciones no están funcionando, no sabemos si van a ser todas interoperables, no sabemos si los países, los Estados miembros realmente van a sacar apps a tiempo. El caso paradigmático de España, que está trabajando en ella, pero probablemente llegaremos tarde simplemente porque ha faltado esa coordinación. En ese sentido, yo le quería preguntar que esta debilidad respecto a los gigantes tecnológicos, sobre todo norteamericanos, el caso de la tasa Google es paradigmático, lo que hace es tener un gigante como la Unión Europea con los pies de barro en lo que es la coordinación y la soberanía digital de todo el espacio comunitario. Y quería saber su opinión en cómo podemos avanzar a conseguir esa verdadera soberanía digital, pero intentando hacer entender a los Estados miembros que la única manera de ser más fuertes es hacerla de manera unida y no de manera individualista. Y agradeciéndole de nuevo que haya estado aquí con nosotros hoy, le cedo la palabra y esperamos verla de nuevo dentro de este marco del diálogo estructurado con la Comisión Europea en los próximos meses. Muchas gracias, señora Vestager. La palabra es suya.
Well, thank you very much. First, a series of specific answers, and then I will end with the tracing apps. On the first questions of competition rules, well, competition rules, they are being applied, but we have sort of enlarged our scope with the temporary framework that is indeed supposed to be temporary. Because we need, of course, to come back to a single market where businesses are not supported in the effect that we see now, but that they stand on their own feet because customers like their products, their prices, their innovative capacity. But in order for businesses to do that, of course, they need a unfragmented single market. And here we have a task force that we have set up with member states. We have made a full report of all the barriers to the single market, and we will now try to fend off all of these barriers one by one on this single market enforcement task force in order for businesses and citizens to have the full effect of the single market. On the question by Ignacio del Bianco, of course, I commit completely to work with the European Parliament, and we can come back when the report is done and when our public consultation is over. I think it is very important to have an open public consultation and not to have fixed views beforehand. So in that respect, we will come back to that. On Mr. Legondinski question on e-government, well, I completely agree to that. The thing is that member states are very, very different when it comes to the use of e-government. Some are very, very digital, some are not so digital. But I'll be more than happy to come back to see how that can be pushed, of course, with the necessary cybersecurity provisions, because when you deal with government, well, very often you also deal with very personal matters. That can be social matters, unemployment, childcare, health provisions. So, of course, it's a special issue that we're dealing with. Very happy with Mr. Stankanelli's remarks. Of course, looking very much forward to work together. Monsieur Morel addressed the question of the digital giants, and of course I see the same thing as you do, that they have grown dominance because of attractive products, and it is indeed a challenge for that market to keep open. I may be the first or the first who's having an obligation to realize that with the work on competition law enforcement. when we take a decision on illegal behavior, for instance, in a Google case, there is a fine to punish past behavior. There's a cease and desist decision to stop what you're doing and do not put anything with the equivalent effects in place. And then thirdly, how to have competition come back. And this is indeed still work in progress. We have not seen the results yet of sort of the preference menu of phones that consumers can choose other search engines and browsers if they buy a phone where Google products are pre-installed. But of course, we need to keep working on that in order for competition to come back and not for the illegal behavior leading to a situation where the ones who have done the illegal behavior basically gets to own that market, because it has very serious repercussions. I'm also the first one to push for us to be able to work faster. But there's one thing that I cannot compromise on, and that is the rule of law. The right to protect oneself, the right to defend oneself, that we have the obligation to prove our cases. Of course, one can discuss whether we could make better use of rebuttable presumptions. I'm very open to do that, because you are indeed right that speed is of the essence, in particular in markets that are moving very fast. Just one remark on liability. The risk concepts that we are suggesting for artificial intelligence, well, the risk is whether or not there is a risk to something fundamental. For instance, the right not to be discriminated. And I think it's also very important and very interesting to discuss, well, how will liability then apply? Both in risky applications and technology and non-risky application. But I'd be more than happy to come back. But what is of the essence of this risk-based approach is that it is indeed a risk to fundamental values, to our health and well-being. And I think maybe also the discussion of liability could be attached to that. So not at all skeptical on that point. Then on tracing app and traceability, the remark on the fact that most people, they are being traced more or less all the time. If you accept terms and conditions, very much so, you have also accepted tracing. I find it's very important that it becomes much more user-friendly to opt out of that kind of tracing. I just saw new services that are being developed so that you can sort of once and for all make sure that your preferred privacy choices, well, that they cover no matter what you do. They cover your browsing, they cover the use of apps, because this is indeed what we need. You cannot spend your life tracing the cursors as to your preferred privacy choices. We need that kind of services that will allow us to remain traced with our phones while still being able to use the services. Of course, it comes with a consequence that the phone doesn't know where you are. You have to tell it yourself. But with that little inconvenience, you get the convenience of not being traced all the time. And when it comes to the virus tracing apps, this has been a very, very long process because we have been trying to make member states convene on some of the basic principles that was just mentioned by the chair, that they are decentral, that only so much data is being placed on the phone as at all needed, that privacy is of the essence, and that it is truly for real voluntarily. Now we have consensus -1 on the decentralized approach. The technical specifications for interoperability have been decided. It's very important for us that we remain on the voluntary basis, that it is indeed voluntary if you want to have the app or not. I do hope that for some of the apps that are not born with interoperability, that in coming updates, that interoperability will be enabled. And we have discussions about a structure that will allow for the exchange of information so that it indeed work cross-border, also with different health authorities. So there is still work to do, but I think it is moving in the right direction. The last question on whether this sort of member state-based approach and trying to achieve consensus, whether this is a weakness that shows that we will not be able to get digital sovereignty. That I don't know, because it also comes with strength that we have a decentralized development, because then there is a lot of knowledge in every member state about what to do and what not to do. And we also have a direct link between the state and the citizen in every member state. And that could be part of building the necessary trust to use the technology. Because I think that the knowledge that it is decentralized, that it doesn't do anything but what it's supposed to do, that data is not stored, and that it is truly voluntary, whether you want it or not, that it is what gives you the trust to do so. Then I realized that I forgot to answer questions on 5G security. We're very happy with the toolbox that we developed with member states. By the end of this month, we will have a status report about how that is being used, because 5G is indeed the backbone of industrial digital development. So it is very important that this is secured. And there are still intense debates in member states about how to deal with this. Also here, of course, we hope that the European approach, that we assess the risks, that we develop a toolbox to address the risks, that will lead to a European consensus where there is a true ownership in each and every member state to follow this European consensus, and then, of course, implements it, because we do need the implementation of 5G, of virus tracing apps that you can trust, on legislation, both on the digital giants, but also how to enable smaller digital players born here in Europe to play their full role, because only then can the digital transition be part of our recovery, and only with that sense of urgency can we make sure that people stay secure and trustful in the transformation of our societies, that we can use digital tools to make better societies, because that is indeed what it means to be fit for a digital age. That is, that we make best use of digital technologies, not to make us all more digital, but to provide for better and more inclusive societies. Thank you.
Thank you very much again, Vice President Vestager. It was a pleasure to have you today with us, and as said, we are looking forward to have you physically in a future meeting. We move on now to item 5, framework of ethical aspects of artificial intelligence, robotics and related technologies, and I would like to give the floor to the rapporteur, Mr. García Blanco. The floor is yours.
Muchas gracias, presidente. Me encuentro otra vez en este comité, frente a este comité, para hablar de este report que acabamos también de tocar superficialmente en las preguntas que le hemos hecho a la vicepresidenta Vestager, y efectivamente este comité y este Parlamento lleva la delantera. Ha comenzado en la vanguardia de lo que puede ser una regulación que en sí misma también es una vanguardia a nivel mundial. Me gustaría comenzar por agradecer a todos los shadow reporters